Here we go.
All right. Well, my meeting is saying something. Oh,
Streaming live.
I don't know. We're live. Hi. Hi,
Hi.
everyone.
Hi.
Welcome to, welcome all you fellow splitting geniuses to another episode of Splitting Smart. And we're back with insights and expert advice on all things divorce, breakup, and well-being. So I'm your host, Lila Aiken Ali, and I'm joined with my co-founder and co-host, Heather Steer. And if you're navigating the complexities of family law in California, I think this interview is for you. We'll be debunking the myths, shedding light on misconceptions, and uncovering invaluable insights that could also reshape your understanding of family law and legal counsel. And we're thrilled to welcome Joel D. Schwartz, a distinguished family lawyer based in Los Angeles. And he brings a wealth of experience and expertise to the table, specializing in divorce, child custody, and prenuptial agreements, among other things in family law.
Thanks for having me. I'm excited to be here.
Yeah.
Welcome, Joel. Joel currently practices at Fox Rothschild. And whether you're contemplating divorce or want to deepen your understanding, particularly in some California nuances, you are in for a real treat. So just a little bit of housekeeping on YouTube. If you have any comments or questions, you're welcome to put them in the chat. I'll be monitoring that, and we'll try to get them to them during the show. Otherwise, afterwards in the show notes. So Joel, you wrote an awesome article about debunking associated with divorce here in California. And these are things that I hear so often from clients and community members that are just sort of just things that people believe about divorce. And whether it's maybe something happened in their cousin's life or their sisters or whatever, or they just read something on a Facebook community page. And so I am really looking forward to this conversation where we can sort of take that off the table for a lot of people, because I do think they can be very limiting beliefs. So let's get this going.
Great.
Yeah. Well, one of the ones, okay, so you read this very comprehensive article, which we will also let all of you know where to find it, because we're not going to go over probably every single one, just given the time, but we chose about 5 to 6 that we thought were really important for people to hear, because we do hear it quite a bit and ask these questions as well. So the first one is around the domestic violence. And, you know, it's kind of like elaborating around on the broader definition of domestic violence in California and what constitutes that, you know.
Yeah, so when you hear domestic violence, oftentimes people think of assault, battery, you know, something that is actually violent, you know, a touching of you know, some kind. But domestic violence is much more broad than that. In fact, now there is, I'm going to say recently, something called coercive control, which is a form of domestic violence that some people have not heard of before. But it's a way of controlling your partner's movements or economics. I'm not going to let you use my car. I'm not going to give you any money. I don't want you going out with this person and hanging out with these folks. I don't want you going to this place. And that is a form of domestic violence. What's difficult is there's typically control in every relationship. Somebody's always controlling someone else in some form or another, and maybe both parties are controlling each other. You know, I don't want to clean this, or I don't want to do that. I don't want you to go out with this person, or I don't want you to buy this. But coercive control is more specific. It has to do with controlling a person's movements, controlling economics, those types of things. And if there is coercive control, a court can issue domestic violence restraining orders.
Amazing.
Yeah.
And also really good, you
know. Well, and we do hear a lot about particularly the financial control, which people, you know, definitely, it doesn't hit someone's radar when they're being financially controlled or they don't know about the finances, which is very typical. Like it's an honest thing that you do when you're in a relationship is to take on certain responsibilities in your marriage, right? So it's, there's no judgment around, I happen to be the one that runs all the household activities, kids' lives, whatever. And then my husband might be the one that controls all the finances. But I think that nuance of that coercive control, where it's something like, you get access, here's $100 a week for groceries type of behavior, is very different than just having a division of duties, right?
Right. And that's, frequently I hear, he or she controlled the finances and I did this or that. I either took care of the house or I worked and that's not necessarily coercive control. It's just a division of, things to do during the marriage, division of activities. But coercive control is when, you ask and the other person is saying, no, you can only have this, or no, you can't go out with that, or you can't go here, you can't go there. That's when you get into more of the domestic violence area, as opposed to just control. And it's not just coercive control. There's other means of domestic violence, stalking somebody, following somebody, hiring an investigator to follow them. If you're putting them in fear, then suddenly it gets into the realm of potential domestic violence. So there isn't just coercive control, there's stalking, there's those types of issues as well. There's, threats, creating emotional stress for somebody and making them feel like they're in danger. Those are also areas that can potentially be found to be domestic violence. And if you have domestic violence, the court can issue very strict orders against somebody, especially if you have children. You have to be supervised around the children. You have a restraining order. You can't come in with a certain, a certain feet or miles or whatever it is of the other person's work, car, home, you name it.
Right. And also I can imagine with now social media being also a play into all of this, where, there is a lot of that they use that control. Like I do know certain, some clients and members of our, community have suffered that. It's like, the blaming and the saying they're bad parents on top of everything, like these kind of things. I don't know what that falls under. It's defamation. Is it domestic violence? I don't know what it would fall under, but that I imagine that you're seeing a lot of cases that deal with also what happens on social media as well.
Yeah, that's not necessarily domestic violence. That's disparagement. And, you're usually struggling with a person has a right to freedom of speech. However, you can't use that speech to disparage somebody that's going to impact the children. If the children hear about it, now suddenly the court can get involved and say, wait a minute, okay, the children can go on social media and they're hearing that you're disparaging the other parent. That's contrary to the children's best interests, and the court can step in and issue certain orders.
Great. Very good to know. So the other myth, we'll move on because I know we want to get through some other ones, is the premarital agreements. Are they enforceable? How are they enforceable? The timelines, all of that's, around the premarital agreement. So.
Right. And, the way the law works is if you dot your I's and you cross your T's, you have full disclosure of assets and debts prior to signing the agreement. A party has this, a substantial amount of, I'm not going to say a substantial amount, reasonable period of time to consider the agreement. Both parties are represented by competent counsel, neither party's under duress. Typically, the court's going to enforce the agreement as long as, all of the, like I said, all the I's are dotted and the T's are crossed. And there's all sorts of rules surrounding prenuptial agreements, but, if you have somebody who knows how to write them, oftentimes they are enforced.
And is there a particular timeline that you need to give that notice and have it taken care of before you actually, get married?
Yeah. So oftentimes you'll hear of the 7-day rule. There's a 7-day rule in California, which means that the parties, or at least the party who is having the agreement enforced against, had to have had the agreement, the final version of it, at least 7 days in his or her hands before signing it. Okay, it's not 7 days before the wedding. You can sign the agreement up to the day of the wedding. But if you haven't had the final version of the agreement in your hands at least 7 days before you sign it, the court's going to find that it's not conscionable, that it's unconscionable, that it's not enforceable. That is a rule in California. That's the 7-day rule. Again, it's not 7 days before the wedding. It's having the agreement at least 7 days in your hands before signing it.
Got it.
That's, and oftentimes people say, well, what if I, start the agreement, 2 weeks before the wedding or a week before the wedding, or you have to run up against that 7-day rule. And again, the closer you get to the wedding, the better the argument that either party has that I signed the agreement under duress because, the wedding was coming. We had all of our invites. We had reservations for the venue and the cake and the photos and this and that. And, I was given this agreement and I had to sign it. So I was under duress. And that's a reason for the court to invalidate the agreement. Or another reason you don't have it at least 7 days beforehand. And again, if you don't have an accurate financial disclosure, meaning you have all your assets and debts that you've provided to the other side, if you don't do that, the court can invalidate the agreement. If you have provisions in the agreement that deal with child support or child custody, the court's not going to enforce those provisions. You can't negotiate a child's right to child support in a prenuptial agreement. You can't adversely impact that child's rights to child support. And child custody in California is always modifiable based on a change of circumstances. So you may have, well, if we have children, it's going to be 50-50 custody. I'm going to have 50% physical custody and you'll have 50% physical custody. Well, what if after they have a child, one person is just not capable of doing that?
Right.
That's why the court's not going to enforce those types of provisions.
Great. Also, I know this is a short one, but the common law marriage.
The 10-year rule. Yes, you often hear that. I've been married for 10 years. I haven't been married for 10 years, or I have been married for 10 years. What happens?
Right.
There is no common law marriage in California. Okay, so if you're not married, you're not married. Now, there is a palimony action if you're together with someone for any period of time and you're cohabitating with that person, and you're sharing finances, and perhaps one person tells the other one, you don't need to work, I'll take care of everything, and then they split up. What rights do you have? It's not a family law case. It's a civil case, and it's a case called palimony. It's almost like a breach of promises, a breach of contract type of an action. I wouldn't have quit my job, or I would have worked had you not promised to take care of me. But that's not a family law case.
Right.
There is a 10-year rule in California, but it pertains to spousal support. And it's in the legislature, it's a statute. And the statute basically defines marriages of 10 years or more from the date of marriage until the date the parties separate as a marriage of long duration. And for marriages of long duration, the court can basically order spousal support until either party dies or the support recipient remarries. It could be a very long time. So oftentimes people will say, let's stay together until that 10-year mark, and then I'll be able to get full lifetime spousal support. Well, the court can still deem the marriage, if it's not 10 years, a marriage of long duration. And the court can terminate spousal support for marriages that are of a long duration. So, it is a statute that says if you are married for 10 years or more, it is a marriage of long duration. But that doesn't necessarily mean that the court can't terminate spousal support at a certain point.
Right.
And aren't you seeing that the temperature of the courts and some of the case law, like, the Gavron warnings and things like that, are really directionally not putting people in a lifetime support position greater than 10 years, even in today's world? Like, I know that statute's a little dated.
Yeah, no, I agree with you. Gavron warning, meaning that you have to be self-supporting within a reasonable period of time, et cetera, et cetera. It just means that, the support recipient should go out and find work. And if they don't within a certain period of time, the support payer can come back to court and say, this person's is not trying to find work. And you can ask the court to reduce the spousal support or terminate spousal support. And that is happening more frequently. Spousal support is very liberal in terms of spousal support, though. California is. Did I say California? California is very liberal in terms of spousal support versus other states. So, spousal support awards can be very high here and can be long-term.
Right.
So, but people will oftentimes go back to court after a certain period of time and say, please reduce spousal support because the other, my ex is not out there trying to find work and not out there working, trying to help support themselves.
Yeah. So there's so many things. But one of the things that we often hear in our community is this idea behind the difference between legal separation and divorcing, right? And so, they file for separation, but they don't realize that that's actually not divorce. So could you maybe go into and clarify a little bit of that? And should people even get that legal separation, rather than just separating and then filing for divorce?
Well, so first of all, you're not legally separated unless the court orders that you're legally separated, finds that you're legally separated, or the parties agree on a date of separation and the court, stamps that agreement. And the date of separation is based on all sorts of factors. Are you still living together? Are you having marital relations? Are you representing to everybody else that you're still together? Are you filing joint tax returns? Do you still have joint bank accounts? Has one party told the other one, I'm done, I want a divorce? All sorts of factors. If the parties can't agree, that's what the court will look at. Even when you file a petition for dissolution of the marriage or legal separation, you can check either box. It doesn't mean that you're legally separated. Oftentimes people will file and then maybe they'll go to a therapist and try to work on their relationship, or they'll continue to have marital relations. So the filing doesn't necessarily mean that you're separated. And you can check the legal separation box. And oftentimes people will check that box either because they want to lessen the blow to the other, their spouse, that they want a divorce, or because they just recently moved here from a different state. Because if you move here from a different state, you can't file for divorce unless you're actually residing here, unless you are domiciled here. So oftentimes people will move here and check the box for legal separation, and they can file for legal separation. And then if they're here for 6 months and they're living here and they have an intent to remain here, they can then convert the case to a dissolution of marriage action. So that's another reason why they'll check that box. But it doesn't mean that you're legally separated. Unless there's an agreement between the parties or there's a court order finding it, you're not separated.
I think it is confusing for people because I get a lot of people asking that when you have this data separation versus this concept of legal separation, like it is two different components of two different legal actions. Yeah. One is you're heading down a path where you're going to get divorced, your relationship over. Otherwise, you're legally separated. You're still, technically married, and you go through a very similar process of full disclosures and negotiations going through a legal separation that then you have to do that again if you're going through a divorce finally. Like it's almost having to do it twice, I feel like.
That's a really good point to make because, some people, their finances are so interwoven. Maybe they have companies together. Maybe there's just so many assets and it's just so hard to unravel. Maybe they want to stay married, but they want to have a legal separation. They can do that. They can have an entire case and be legally separated at the end and have spousal support and child support and division of assets, but they'll still remain married. So it's very similar to a divorce action. It's just at the end of a divorce action, you're single. At the end of a legal separation, you're still married, but everything can still be divided and you can have orders for spousal support, child custody, all those things. So you can do that.
But then should you wish then to get divorced down the line? Let's say that you meet somebody else and you decide, oh, maybe I want to get remarried. You're going to have to go through that whole process again.
Not necessarily. If you have a judgment, a court order that says everything's been divided, et cetera, it doesn't matter if we, want to get divorced. We don't have to go through this again. I mean, you can basically just do that. And frankly, in my career, I've never had a case where the parties had a legal separation action all the way to the end. At least not that I can recall. Because if you're going to go through that, why not just have a divorce?
Right.
Right.
That's what I'm thinking.
Yeah.
I'm like, oh, it's the same process. But I think that part of it comes up because of that confusion between the concept of people think like, oh, I'm legally separated from my husband or wife as I'm going through the divorce process, because you have a date of separation established, right? Because that's the term in the divorce case. Like, here's our date of separation of ending of community assets, right? And so I think there's just some noise in those, the words sounding so close together.
I would think a potential concern is with respect to third-party creditors. So if you are legally separated, but you're still married, and the other party, it may be the other party's credit card, they go out and they charge and they don't pay. I would imagine, I don't know this for sure, that third-party creditors can still go after the other party's assets because the parties are still married.
They're still married. Exactly.
So you can have terms in your judgment saying, oh, well, her assets are hers and his assets are his, and his debts are hers and her debts are, her debts are hers, his debts are his. You can have terms like that in your final judgment, but that doesn't apply to third-party creditors. Visa's not going to, Capital One's not going to care if, somebody charges on their credit card and they don't get paid for it. You're going to say, well, I have a judgment saying that those charges are his. Capital One's not going to care. They're not bound by that. I say Capital One, any third-party creditor.
Yeah, it's
we could go on with so many. I'd love to have you back and have some more, insights on all of this, hopefully. But I did want to say one thing that I think should be, and I don't even know if you had this on your list, but it does come up a lot: attorney's fees.
Yes. That's
yes.
a big one.
A big one. Everyone thinks that they can get granted attorney's fees, right?
Right.
And I think that is a misconception, because we know it is quite difficult actually to obtain. So I don't know if you want to just shed a little bit of light on that.
Yeah. So, what the court tries to do in California is to level the playing field so that both parties have equal access to representation. So that way, if you have one party who has a lot of money and assets and the other party who doesn't, it's not fair. Okay,
Right.
because the party who doesn't, maybe they don't have enough money to hire counsel or to maintain counsel throughout the divorce. So that party can go into court and ask the court to order the other party to contribute to his or her attorney's fees. And if there is an uneven financial difference between the two, one party has more than the other, the court will order it.
Okay.
So yeah, I don't see it being difficult if you have that situation. Now, you could have a fair amount of assets and a fair amount of income. That doesn't mean that you're not going to be able to get a contribution ordered by the court. If the other side has more, you can still get a contribution. So, and you can do that throughout the case and at trial. So you can continue to go back in once the money's gone and ask for more. It doesn't mean that the court's going to order it, but you can certainly ask, and you have a right to ask. So again, leveling the playing field.
Right. And that's something you should be doing right up front then. It's something
you should.
that, yeah. Right.
Yeah, absolutely. And typically what we'll do is we'll ask, if I'm representing the quote unquote out spouse, the one who doesn't have the money, I will ask the other side to contribute. And if they don't agree, you have to go to court.
Got it.
Because otherwise it's just not fair. The other party can get trampled by the party who has the money.
Right.
They can hire the most aggressive lawyers and just throw everything at it. And then the other party who has no money is gonna get trampled. And it's just not fair. So the court will try to level the playing field.
That's actually really good to know.
Yeah.
I don't know anything else. I mean, there's so many things that we can go over, but I know I just wanted to, keep it, given your time, and, we really appreciate it, because this has been super insightful, really insightful. And I think, there's, we were joking, I think even earlier today, I was saying that when you tell somebody you're going through a divorce, and all of a sudden everybody is an expert around you.
Right. You often hear that. my friends got this, or my friend got that, or my friends
Yeah.
are telling me to ask for this or
Yeah.
that. Everybody's
Yeah.
case is different, you know.
Totally. Totally. And and then it's all this misconception. A lot of times people are like even learning from, television. So again, it's funny because I was just watching a show about, it's called The Split. I think it takes place in Britain where I got my divorce. And I will say that it's totally off. Like everything that was happening, I was like, well, that can't happen. I know that can't happen. I'm not
Right.
even legal counsel, but I went through the process. I know exactly it's not even side by side like what they're allowed to do. Right. So I was like, good thing people aren't learning from that,
Yeah.
hopefully.
Right. Maybe it just makes for better television, you know?
Makes for better television.
Yeah.
Absolutely. So, but yeah, this was great. Thank you, Joel.
My
Seriously.
pleasure.
And we're gonna put how to find your article in our show notes. We will, share your information with everyone. Anybody who's in California, LA, please, you're like, for me, you're my go-to referral because I just,
Thank you.
I've, my clients who have worked with you, I see the way you work and I really appreciate lawyers like you. So thank you so much, really, for
Thank you.
being.
It's been my pleasure.
Thank you,
Thank you.
Joel. This is great.